Hello everyone, we the students of IMS are going to give presentation on the topic Contract for Sales of Goods as per Sales of Goods Act 1930. My name is Nikita visbaiya and I'll be explaining the introductory part which will include formation of contract of sales, essential elements of contract of sale and what are the formalities followed in the contract of sale. Now we'll see the background history of this act. The introductory topic Contract for Sale of Goods as per Sales of Goods Act 1930. Definition of Sale of Goods Act 1930. It is a provision for setting up of contract where the seller transfer or agree to transfer the title, that is the ownership in the goods, to the buyer for consideration. Now what are the applicability of this act, as this act extends to whole of India except the state of Jammu and Kashmir. It came on force on 1st July 1930. This act includes a contract of sale which includes sale as well as agreement to sale. This act does not consider sale of immovable property. Example, sale, lease, gifts, etc. as these are governed by a separate act known as the Transfer of Property Act 1882. Under this act are first, buyer. Buyer will be a person who buys or agrees to buy the goods. Delivery. Delivery means voluntary transfer of possession from one person to another. Goods. Goods are said to be in deliverable state where the buyer would under the contract be bound to take delivery of them. In this act, only movable property other than actionable claims and money and includes stock, shares, growing crops, grass and things attached to or forming part of the land, which are agreed to be served before sale or under the contract of sale. Document of title of goods. It is a document used in the ordinary course of business as a proof of the possession or control of goods, or authorizing or purporting to authorize either by endorsement or by delivery. It includes a bill of lading, dock warrant, warehouse keeper certificate, railway receipt, warrant or order of the delivery of goods and any other document. Fault. Fault means any wrongful act or default. Future goods. The goods which are manufactured or produced acquired by the seller after the making of the contract of sale. A person will be insolvent who has ceased to pay his debts in the ordinary course of business or cannot pay his debt as they become due, whether he has committed an act of insolvency or not. Mercantile agent. This agent having the customary course of business as such agent authority either to sell goods or to consign goods for the purpose of sale, or to buy goods or to raise money on the security of goods. Price. Price means the money consideration for a sale of goods. How the contract of sale is being formed. So, a contract is signed when the seller transfer or agree to transfer the goods to the buyer for a price, or the buyer agree to buy the products or the goods from the seller for a price. There must be contract of sale between the two parts owner, or there can be another. Contract of sale includes sale as well as agreement to sale. Now what is sale? Sale is when the property in goods is being transferred from the seller to the buyer. This contract is called sale. But when the transfer of the property in the good is to be take place at a future time, it has not been taken place at the current condition, but it has been promised to take place at some future time or subject to some conditions. Conditions can be the demand or the requirement of the buyer or the seller is being fulfilled. Then this contract is called as the agreement to sell. This agreement to sell will become sale only when the time has been elapses, that is the future time has been came, or the conditions like demand or requirement are being fulfilled, or the subject to which the property in the good to be transferred are fulfilled. This is how a contract is being formed between the two parties. Under this act, there are certain essential elements which are being required. First is presence of two distinct parties, that is a party A and party B. More than two parties can also exist. Second is goods. the goods should be present in the form of movable property. Immovable properties does not come under this act. Third is price. The exchange of goods must be in presence of certain amount of price. That is, a buyer must give a considerable amount of money to the seller in return of the goods. Then, transfer of property. That is, when the seller transfers the goods to the buyer, he is transferring the ownership to the buyer. But this ownership, when the sale is immediate and the buyer has given amount of money to the seller, then only this will be absolute ownership. Otherwise, when there is an agreement signed between the two distinct parties and the goods are not being exchanged immediately but for the future time, or it has been promised to give for the future, then this will be called as the conditional ownership. Now at the last, all the essential elements should have a valid contract. That is, elements of contract must be a valid contract. That is, all the information given in a contract should be valid. A seller will be a person who sells or agrees to sell the goods to the buyer who will buy or agree to buy the goods. Now goods are the movable properties. Immovable properties does not come under this act. Now when the seller sells the goods, for example, a seller wants to sell 100 bale of cotton to the buyer. Now when the buyer will immediately purchase the cotton from the seller in presence of price, money for consideration, then he will become the absolute owner of the cotton. But when the seller signs an agreement to sell the goods to the buyer for some future date, this is when the transfer of ownership to the buyer is not absolute but conditional, because buyer has not given a consideration amount of money to the seller. So transfer of ownership, when the seller will sell goods to the buyer immediately, this is when the buyer will become the absolute owner of the goods. But when there is an agreement signed between the two parties for some future date, that is, the seller promises to give the goods to the buyer for the future date, or the buyer will sign an agreement to take the goods from seller in some future date, this is when the transfer of ownership between the seller and the buyer will be conditional. Contract of sale. Section 5 of this act provides the following 3 steps or formalities in a contract of sale. First is the offer and acceptance. A contract of sale is made only when there is an offer to buy or sell the goods for a price and acceptance of such offer. That is, a seller agrees to sell the goods for the price to the buyer and there is the acceptance of such offer from the buyer to the seller. Second is delivery and payment. It is not necessary that the payment for the goods to the seller and delivery of goods to the buyer must be simultaneous. They can be made at different times or in installments as per the contract. Third is expressed or implied. The contract can be in writing, oral or implied. It can also be partly oral and partly written. Effect of destruction of goods. Section 7 of this act says that goods perishing before making of contract. A contract for sale of specific good is void if at the time when the contract was made the goods have without the knowledge of the seller perished. The same would be the case where the goods become so damaged as no longer to answer to their description in the contract. For example, A sold specific goods to B which were lying in A's godown. Unknown to both the parties, the goods got destroyed due to fire. Such contract is void. Section 8. Goods perishing after the agreement to sell but before the sale is affected. An agreement to sell specific goods become void if subsequently the goods without any fault on the part of the seller or the buyer perish or become so damaged as no longer to answer to their description in the agreement before the risk passes to the buyer. For example, John delivered a horse to Johnny for a trial for 8 days. It was agreed that the sale would be complete if the horse was found suitable for the Johnny's purpose. The horse died on third day without any fault of either party. This contract was void and John would not recover the price from Johnny.
Hello everyone, my name is Nikita verma and I will carry forward with Sale of Goods Act provisions relating to conditions and warranty. कंडीशन का मतलब होता है ऐसी शर्तें जो किसी गुड के मेन पर्पस के लिए असेंशियल हो. जब इन शर्तों को तोड़ा जाता है तो जो बायर है वो उस कॉन्ट्रैक्ट को खत्म कर सकता है या फिर रिफंड की डिमांड कर सकता है. वहीं अगर वारंटी को देखा जाए तो वारंटी ऐसी शर्तें होती हैं जो कोलैटरल होती है मेन पर्पस से, एडिशनल होती है मेन पर्पस से. जब इन शर्तों को तोड़ा जाता है तो बायर सिर्फ डैमेजेस के लिए क्लेम कर सकता है, वो रिफंड की डिमांड नहीं कर सकता, वो कॉन्ट्रैक्ट को कैंसिल नहीं कर सकता, सिर्फ और सिर्फ डैमेजेस के लिए क्लेम कर सकता है. कंडीशन को हम और डिटेल में देखते हैं. ब्रीच ऑफ कंडीशन को हम एक एग्जाम्पल के थ्रू समझते हैं. सपोज एक्स एक बायर है, वाई एक सेलर है. एक्स बोलता है कि मुझे एक ऐसी गाड़ी चाहिए जो मुझे 20 किलोमीटर पर लीटर का माइलेज दे. वाई उसे एक गाड़ी की तरफ पॉइंट करते हुए बोलता है दैट दिस कार इज गोइंग टू सूट यू. एक्स उस गाड़ी को परचेज कर लेता है. लेटर ऑन ही फाइंड्स आउट कि वो गाड़ी 20 का नहीं 15 का माइलेज दे रही है, क्योंकि एक्स के लिए एक कंडीशन थी कि उसे ऐसी ही गाड़ी चाहिए. तो इसमें हुआ है ब्रीच ऑफ कंडीशन. इन दिस केस एक्स उस कॉन्ट्रैक्ट को कैंसिल कर सकता है. सो ये होती है ब्रीच ऑफ कंडीशन. कंडीशन दो टाइप की होती है, इम्प्लाइड कंडीशन और एक्सप्रेस कंडीशन. इम्प्लाइड कंडीशन का मतलब होता है जिसे कॉन्ट्रैक्ट में मेंशन ना किया हो लेकिन लॉ के थ्रू इसे पहले ही अज्यूम कर लेते हैं कि ये तो एप्लीकेबल है ही. कंडीशन के 7 टाइप्स होते हैं. फर्स्ट इज कंडीशन एज टू टाइटल. कंडीशन एज टू टाइटल का मतलब है कि सेलर जो गुड सेल कर रहा है उसके पास उस गुड का टाइटल है भी कि नहीं. अगर वो उस गुड का ओनर नहीं है तो उसके पास कोई राइट नहीं है कि वो उस गुड को पास ऑन कर सके. नेक्स्ट है कंडीशन एज टू डिस्क्रिप्शन. अगर बायर उस गुड का सैंपल नहीं देख रहा है, वो सिर्फ जैसा डिस्क्राइब करा है सेलर ने उस पर ट्रस्ट करके उस गुड को खरीद रहा है तो वो गुड वैसा ही निकलना चाहिए. ये पैकेजिंग में भी एप्लीकेबल है कि जैसी पैकेजिंग डिस्क्राइब की गई है सेलर के द्वारा वैसी ही पैकेजिंग रिसीव होनी चाहिए बायर को, या फिर बायर ने जैसी पैकेजिंग मांगी है वैसी पैकेजिंग उसको मिलनी चाहिए. नेक्स्ट इज सेल बाय सैंपल. सेल बाय सैंपल का मतलब होता है कि अगर किसी को बहुत सारे गुड्स लेने हैं तो वो सारे ही चेक नहीं कर सकता. वो एक सैंपल देख लेगा एंड देन ही विल डिसाइड कि इस टाइप की मुझे सारे गुड्स चाहिए, और अगर वो फॉलो नहीं होता है तो दिस इज ब्रीच ऑफ कंडीशन. नेक्स्ट इज सेल बाय सैंपल एंड डिस्क्रिप्शन. इसमें जैसा सैंपल दिखाया है और जैसा डिस्क्राइब करा है दोनों चीज़ों को फॉलो करना कंपलसरी है सेलर के लिए. कंडीशन एज टू क्वालिटी और फिटनेस. इसमें जो बायर है वो एक स्पेसिफिक क्वालिटी का गुड डिमांड करता है तो जो सेलर है वो उसे ऑर्डिनरी क्वालिटी का गुड नहीं दे सकता. जो बायर का स्पेसिफिक पर्पस है वो फुलफिल होना चाहिए. नेक्स्ट इज कंडीशन एज टू मर्चेंटेबिलिटी. मर्चेंटेबिलिटी का मतलब होता है जो गुड्स है वो कमर्शियली सेलेबल होनी चाहिए. अगर जो सेलर है वो डीलर है उन प्रोडक्ट्स का तो ये इम्प्लाइड होता है कि वो अच्छी क्वालिटी का गुड ही देगा, तो उसे इस शर्त के ऊपर ट्रस्ट के साथ काम करना चाहिए. नेक्स्ट इज कंडीशन एज टू होलसमनेस. इसका ये मेनली एप्लीकेबल होता है फूड आइटम्स पे. जो फूड आइटम्स जितने भी एडिबल आइटम्स होते हैं वो सब फिट होने चाहिए ह्यूमन कंजप्शन के लिए. तो ये सब होती है इम्प्लाइड कंडीशन जो लॉ में मेंशन है लेकिन इनको कॉन्ट्रैक्ट में मेंशन किया जा सकता है, नहीं किया जा सकता है, लेकिन फिर भी ये लॉ के थ्रू एप्लीकेबल होती है. नेक्स्ट है एक्सप्रेस कंडीशंस. एक्सप्रेस कंडीशन ये भी एसेंशियल होती है मेन पर्पस के लिए कॉन्ट्रैक्ट के, बट इनको ड्यूली मेंशन किया जाता है कॉन्ट्रैक्ट में, इनको लिखा जाता है. ये होती है एक्सप्रेस कंडीशन. वारंटी, जैसा कि हमने पहले पढ़ा था, वारंटी ऐसी शर्तें होती हैं जो मेन पर्पस के साथ एडिशनल होती है, कोलैटरल होती है मेन पर्पस को. और जब इन शर्तों को तोड़ा जाता है, जब इनका ब्रीच होता है तो जो बायर है वो सिर्फ और सिर्फ डैमेजेस के लिए क्लेम कर सकता है. वो रिफंड की डिमांड नहीं कर सकता, कॉन्ट्रैक्ट को कैंसिल नहीं कर सकता, सिर्फ जो उसे डैमेजेस हुए हैं उसकी भरपाई की मांग कर सकता है. इसको भी हम एक एग्जाम्पल से समझते हैं. सपोज एक बायर ने एक गाड़ी खरीदी और उस गाड़ी के साथ वारंटी थी कि वो गाड़ी आवाज़ नहीं करेगी, वो बहुत कंफर्टेबल रहेगी, बट बाद में एक को रियलाइज़ हुआ कि वो गाड़ी आवाज़ भी कर रही है और वो कंफर्टेबल भी नहीं है. तो इस केस में ए जो है वो उस गाड़ी को का रिफंड की डिमांड नहीं कर सकता, वो सिर्फ उस डैमेजेस के लिए क्लेम कर सकता है. वो सिर्फ रिपेयर करवा सकता है उन चीज़ों को जो उसे प्रॉब्लम दे रही है जिसके साथ वारंटी आई थी. वारंटी के भी दो टाइप्स होते हैं, इम्प्लाइड वारंटी एंड एक्सप्रेस वारंटी. इम्प्लाइड वारंटी वो होती है है जो लॉ के थ्रू इम्प्लाइड होती है। हो सकता है वो कॉन्ट्रैक्ट में मेंशन ना हो, बट स्टिल लॉ उसे इम्प्लाई करता है, दोनों पार्टीज को उसे मानना होगा। और अगर वो मानना नहीं चाहती हैं तो उनको एक्सप्रेस करना पड़ेगा कॉन्ट्रैक्ट में कि हम इम्प्लाइड वारंटी को नहीं मानते हैं, दो आपसी अग्रीमेंट के बाद। इम्प्लाइड वारंटी के भी 4 टाइप्स होते हैं। द फर्स्ट वन इज वारंटी एज टू अनडिस्टर्ब पोजेशन। बायर को जो गुड का पोजेशन मिलेगा उसमें कोई डिस्टर्बेंस नहीं आना चाहिए, उसको कंप्लीट पोजेशन मिलना चाहिए, ऐसा नहीं कि बाद में कोई उससे उसका पोजेशन छीनने की कोशिश करे। नेक्स्ट इज वारंटी एज टू नॉन एक्जिस्टेंस ऑफ इनकम्ब्रेंसेस। कोई इनकम्ब्रेंसेस नहीं होने चाहिए, ऐसा नहीं हो कि वो गुड किसी और के पास मनी के अगेंस्ट में प्लेज किया गया हो। वो गुड कम्प्लीटली बायर का हो जाना चाहिए, किसी थर्ड पार्टी का इन्वॉल्वमेंट नहीं होना चाहिए उस गुड के ऊपर। डिस्क्लोजर ऑफ डेंजरस नेचर ऑफ गुड्स। अगर बायर कोई सामान लेता है और अगर उस सामान का नेचर डेंजरस हो सकता है और वो अवेयर नहीं है, तो ये सेलर की रिस्पॉन्सिबिलिटी है कि वो बायर को बताए, क्योंकि अगर आगे चल के बायर को कोई भी नुकसान होता है तो द सेलर विल बी रिस्पॉन्सिबल फॉर इट। नेक्स्ट इज वारंटी एज टू क्वालिटी और फिटनेस बाय यूजेज ऑफ ट्रेड। अगर किसी सामान का ऑक्शन हो रहा है तो जो ऑक्शन करवा रहा है उसकी रिस्पॉन्सिबिलिटी होती है कि वो बताए अगर उस सामान में कोई भी डिफेक्ट है, तो कुछ भी छुपाए ना, सब कुछ डिस्क्लोज कर दे। So this is all about implied warranty. Next, expressed warranty. Expressed warranty का मतलब होता है कि वो कोलैटरल हो मेन पर्पस के लिए, बट वो ड्यूली मेंशन्ड हो कॉन्ट्रैक्ट में, उनका प्रॉपरली लिखा गया हो उनके बारे में कॉन्ट्रैक्ट में। और क्या कभी कंडीशन वारंटी के जैसे ट्रीट की जा सकती है? तो हाँ, कंडीशन वारंटी के जैसे ट्रीट की जा सकती है। दिस डिपेंड्स अपॉन दी बायर। अगर उसके पास कंडीशन है कि वो चाहे तो उस प्रोडक्ट को रिफंड करवा सकता है, उस प्रोडक्ट का या कॉन्ट्रैक्ट को कैंसिल कर सकता है, बट ही चूजेस कि मैं सिर्फ डैमेजेस का क्लेम करूंगा, मुझे कॉन्ट्रैक्ट कैंसिल नहीं करना है, बट जो भी डैमेजेस हुए हैं आप उसको रिपेयर करके मुझे दे दो वापस। सो दिस इज कंडीशन ट्रीटेड एज वारंटी, बट वारंटी कैन नेवर बी ट्रीटेड एज कंडीशन। वारंटी को के एंड में हम दो कॉमनली कंफ्यूज टर्म्स के बीच का डिफरेंस देख लेते हैं, वारंटी एंड गारंटी। वारंटी का मतलब होता है एक अश्योरेंस जो सेलर देता है बायर को कि अगर इस चीज़ में कुछ भी डैमेज हुआ तो मैं आपको रिपेयर करके वापस दूंगा। वहीं अगर गारंटी को देखा जाए तो उसमें सेलर एक प्रॉमिस करता है कि अगर इस चीज़ में कुछ भी खराबी आई तो मैं इसे आपको कम्प्लीटली रिप्लेस करके दूंगा। जो वारंटी होती है वो एप्लीकेबल होती है सिर्फ प्रोडक्ट में, जो गारंटी होती है वो एप्लीकेबल होती है प्रोडक्ट्स, सर्विसेज और पर्सन्स, तीनों पे। जो वारंटी होती है उसके लिए एक पर्टिकुलर अमाउंट पे करना पड़ता है बायर को, वहीं अगर गारंटी को देखा जाए तो वो फ्री ऑफ कॉस्ट होती है। वारंटी जो होती है उसका टाइम पीरियड वेरी कर सकता है आइटम टू आइटम, बट गारंटी जो होती है वो एक लॉन्ग टर्म के लिए होती है। So this is all about conditions and warranty. Now I would like to pass on the presentation to Parth Sharma. Thank you.
Hello everyone, my name is Parth and my topic is Transfer of Goods under the Sales of Goods Act 1930. The term Transfer of Property under the Sales of Goods Act 1930. The term passing of goods or property means there is a transfer of ownership which is governed by the principle of the Sales of Goods Act. In order to understand the rights, duties, liabilities of both seller and the buyer, it is important to understand the concept of passing of property. This principle of law helps to resolve the conflict, to stay away from the bigotry or the misunderstanding while the transaction happens. Types of goods under the Act. Basically, there are 3 types of goods. First being existing goods. Under the existing goods, there are 3 subtypes. First being specific goods. The goods that the buyer and seller already know what are supposed to be transacted are called specific goods. Certain goods. Certain goods are the goods which are basically specific goods, but the buyer and seller before the signing of the contract know what type of good is supposed to be exchanged, and there might not be any specificity in that certain goods. They might have a vague idea what they are selling or what the buyer is buying beforehand. Third subtype is uncertain goods. Uncertain goods are the goods which the buyer and the seller has no idea of the final product. because the product might change due to various reasons. For example, there is a exchange of fruits, like for 100 oranges. The buyer and seller has no idea what type of oranges will grow in the farm of the seller. How it can be defined? It can be defined by various aspects like fertilizer, the land, the season, how it is grown. Everything affects the final product. So it's an uncertain good. Second type of goods are future goods. Future goods are those goods which are produced after the signing of the contract. Like for example, a piece of furniture. A piece of furniture is produced after the signing of the contract because it totally depends upon the type of furniture, or the nuance of the furniture is defined by the choice of the buyer. Third being contingent goods. Contingent goods are the subtype of future goods. In contingent goods, the sale happens in the future. The sale will always come with some contingent clause in it. So the difference between future and contingent good is even the sale also happens. The monetary transaction also happens in the future. The transfer of property in sale of specific or uncertain goods. First being property when intended to pass. Section 19. Where a contract of sale of a certain or specific goods exists, a specific type is fixed as per the convenience or consensus of both the parties at which the property is intended to be transferred from the seller to the buyer. One is to pay attention to the circumstances and conduct of both the parties to the contract in order to understand the true intention of the contracting parties. Also, the terms of the contract should be given equal importance in the existing case. Section 20. Specific goods in a deliverable state. Section 20 says, in a contract of the sale of specific goods, which is unconditional in nature, the goods are transferred from the seller to the buyer at the time of formation of the contract. However, the only precondition required for the transfer of property is the fact that the good must be existing in a deliverable state. The delay in the payment of delivery of goods or both is not something which holds importance. Section 21. Specific goods to be put in a deliverable state. Where there is an existence of a contract of the sale of specific goods, the property concerned in the transaction will only be passed to the buyer if the seller performs the necessary act of omission in order to put the good in deliverable state. Also, it is mandatory for the seller to notify the buyer regarding the alterations. Section 22. Specific goods are in a deliverable state, but the seller has to do something to ascertain the price. Where there is a contract for a sale of specific good in deliverable state, the seller is undoubtedly bound to weigh, measure, test, or to do the necessary demonstration of anything which is required in reference with the sale of those particular goods. He'll be doing this to ascertain the appropriate value of the good. The property in the good will not pass until such demonstration of particular are done and the buyer has acknowledged thereof. Transfer of property in sale of uncertain goods. Section 23. Sale of uncertain goods as an appropriation. It has two subtypes. Section 23(1), which says in contract for the sale of an uncertain good by description, if good of a specific description are appropriated either by the seller with the consent of the buyer or by the buyer with the consent of the seller, then the goods are passed to the buyer. The consent can be expressed or implied and can be given before or after the appropriation is made. The second part says the seller has unconditionally appropriated the property if he delivers the property to the buyer carrier belly for the reason of transmission to the buyer. However, he doesn't reserve the disposable rights to the property, then it can be said that it has appropriated the contract. Goods sent on approval or on sale of return. The goods therein will only pass to the buyer if the buyer either portrays his consent or acknowledges. The goods therein will only pass to the buyer if the buyer doesn't express his concern or acknowledges to the seller he intended to reject the goods. Section 25, Reservation of right to disposal. It again has two types, two clauses. Section 25(1), which states, as per the terms and condition of the contract, the seller of goods reserve the right of disposal of the goods in situation where the sale of specific good is concerned. Despite the delivery of the goods will not get transferred from the seller to the buyer unless the subsequent terms of the contract aren't appropriated or fulfilled. 25(2) is a few perspectives pertaining to the transfer of property during a sale of good or property are encapsulated in Sales of Goods Act 1930. The liability of the buyer and seller are determined in consensus with the provision issued from section 18 to 25 of the Sales of Goods Act. The concept of possession of goods differ from passing to the goods, as the latter in essence means transfer of ownership from the seller to the buyer, while the former is confined to the custody of the goods. Case study. There is a case study which is under the title of Badri Prasad versus the state of Madhya Pradesh. In case of Badri Prasad versus the state of Madhya Pradesh, the appellant entered into a court in respect of certain forests in Madhya Pradesh. He was entitled to chop teak trees with girth over 12 inch. After the passing of the Abolition of Propriety Act, the appellant was prohibited from cutting the trees in the exercise of his right under the Act. He filed a suit claiming specific performance of the contract on the ground, first being the forest and the trees did not vest in the state under the Act. Basically, that means the forest and the trees are may not come under the state under the Act. The forest and the trees are considered separate. Even if they vested, the standing timber having been sold to the appellant did not vest in the state. Third, in any attempt, a new contract was completed on 5th February 1955 and the appellant was entitled to its specific performance. The court held the forest and the tree vested in the state under the Act. The plaintiff was entitled to cut teak trees for more than 12 inch girth. However, it has to be ascertained which tree will be falling in that description. Till this was ascertained, there will not be ascertained goods as per section 9 of the sale of the.
Hello, my name is Aishwarya Bhatnagar. From now onwards, I am going to lead the presentation. Performance of contract of sale. Performance of contract means as regards the seller, delivery of the goods to the buyer, and as regards the buyer, acceptance of the delivery and payment of them according to the terms of the contract. A contract of sale always involves reciprocal promises. The seller promising to deliver the goods and the buyer promising to accept the goods and pay for them. In the absence of a contract, to the contrary, they are to be performed simultaneously and each party should be ready and willing to perform his promise. If the contract contains any special terms as to delivery and acceptance, these must be complied with. If there are no items in the contract to this effect, delivery of the goods and payment of the price are concurrent conditions. That is, both these must take place at the same time, as in, for instance, a cash sale over a shop counter. Delivery means voluntary transfer or possession of goods from one person to another. Delivery of goods sold may be made by doing anything which the parties agree shall be treated as delivery or which has the effect of putting the goods in the possession of the buyer or his agent. Delivery of the goods may be actual, symbolic or constructive. Let's go through each one of them. Actual delivery, where the goods are handed over by the seller to the buyer or his duly authorized agent, the delivery is said to be actual. Delivery of the goods may also be made by doing anything which has the effect of putting the goods in the possession of the buyer. Then, symbolic delivery, where the goods are ponderous or bulky and incapable of actual delivery, the delivery may be symbolic. And then comes constructed delivery or delivery by atonement, where a third person who is in possession of the goods of the seller at the time of the sale acknowledges to the buyer that he holds the goods on his behalf, there takes place a delivery by atonement or constructive delivery. Now there are certain rules regarding the delivery of goods. First, mode of delivery. According to section 33, delivery of goods sold may be made by doing anything which the parties agree shall be treated as delivery or which has the effect of putting the goods in the possession of the buyer or of any person authorized to hold them on his behalf. Delivery of goods may be actual, symbolic or constructive as delivery of the remainder. Payment and delivery concurrent conditions. According to section 32, the delivery of the goods and payment of the price are concurrent conditions. That is to say, the seller shall be ready and willing to give possession of the goods to the buyer in exchange of price, and the buyer shall be ready and willing to pay the price in exchange for the possession of the goods. Thus, delivery of goods and the payment of the price must be according to the term of the contract. Effect of part delivery. According to section 34, a delivery of the part of the goods in progress of the delivery of the whole has the same effect for the purpose of passing the property in such goods as the delivery of the whole. The delivery of the part of the goods with an intention of severing it from the whole does not operate as the delivery of the remainder. Buyer to apply for delivery. According to section 35, apart from any express contract, the seller of goods is not bound to deliver them until the buyer applies for delivery. It is the duty of the buyer to demand delivery. If he does not apply for delivery, the buyer has no cause of action against the seller. The parties may, however, agree otherwise. Place of delivery. According to section 36(1), the place at which the delivery of the goods is to take place may be specified in the contract, and the seller must deliver the goods at that place during business hours on a working day. Apart from any such contract, goods sold are to be delivered at the place at which they are at the time of the sale, and goods agreed to be sold are to be delivered at the place at which they are at the time of agreement to sell, or if not in existence, at the place at which they are manufactured or produced. Time of delivery. According to section 36(2), where under the contract of sale, the seller is bound to send the goods to the buyer, but no time for sending them is fixed, the seller is bound to send them within a reasonable time. According to section 36(4), demand in tender of delivery must be at a reasonable hour. What is a reasonable hour is a question of fact. If the seller fails to do so, he will be guilty of breach. Goods in possession of a third party. According to section 36(3), where the goods are in possession of a third person, there is no delivery unless and until such third person acknowledges to the buyer that he holds the goods on his behalf. Once the third person does this, this amounts to delivery. This rule is, however, subject to transfer of documents of title, where the goods have been sold by the issue or transfer of any document or title to goods. Cost of delivery. According to section 36(5), unless otherwise agreed, the expenses of and incidental to putting the goods into a deliverable state shall be borne by the seller, but all expenses of and incidental to obtaining of delivery are borne by the buyer. Delivery of wrong quantity. According to section 37, the seller is under an obligation to deliver that quantity of goods contracted for. A defective delivery entitles the buyer to reject the goods. There can be following three possibilities. Short delivery. According to section 37(1), where the seller delivers to the buyer a quantity of goods less than he contracted to sell, the buyer may reject the goods. If the buyer accepts them, he shall pay for them at the contract rate. According to section 37, where the seller delivers to the buyer a quantity of goods larger than he contracted to sell, the buyer may accept the whole and pay for them at the contract rate, or reject the whole, or accept the goods he ordered and reject the rest. If the excess is negligible and the seller does not ask any payment for the excess, the buyer may not reject. Mixed delivery. According to section 37(3), where the seller delivers to the buyer the goods mixed with the goods of a different description not included in the contract, the buyer may accept the goods which are in accordance with the contract and reject the rest or reject the whole. Installment deliveries. Under section 38, unless otherwise agreed, the buyer of goods is bound to accept delivery thereof by installment. where there is a contract for the sale of goods to be delivered by the stated installment which are to be separately paid for, and the seller makes no delivery or defective delivery in respect of one or more installment, or the buyer neglects or refuses to take delivery of or pay for one or more installments. Delivery to a carrier or wharfinger. According to section 39, where in pursuance of a contract of sale, goods are delivered to a carrier for the purpose of transmission to the buyer or to a wharfinger for safe custody. Delivery of goods to them is prima facie deemed to be a delivery of the goods to the buyer. In such a case, the seller must enter into a reasonable contract with the carrier or wharfinger on behalf of the buyer for the safe transmission or custody of the goods. Otherwise, if the goods are destroyed, the buyer may decline to treat the delivery to the carrier or wharfinger as a delivery to himself, or may hold the seller responsible in damages. Unless otherwise agreed, where goods are sent by the seller to the buyer by a route involving sea transit, the seller must inform the buyer in time to get the goods insured. Otherwise, the goods will be at seller's risk during such sea transit. Risk where goods are delivered at distant places. According to section 40, where the seller of goods agrees to deliver them at his own risk at place other than that they are when sold, the buyer shall nevertheless, unless otherwise agreed, take any risk of deterioration in the goods necessarily incident to the course of transit. Buyer's right of examining the goods. According to section 41, where goods are delivered to the buyer which he has not previously examined, he is not deemed to have accepted them unless and until he has a reasonable opportunity of examining them for the purpose of ascertaining whether they are in conformity with the contract. Unless otherwise agreed, when the seller tenders delivery of goods to the buyer, he is bound on request to afford the buyer a reasonable opportunity of examining the goods for the purpose of ascertaining whether they are in conformity with the contract. Buyer not bound to return rejected goods. According to section 42, unless otherwise agreed, where goods are delivered to the buyer and he refuses to accept them, having the right to do so, he is not bound to return them to the seller, but it is sufficient if he intimates to the seller that he refuses to accept them. Liability of buyer for neglecting or refusing delivery of goods. According to section 43, when the seller is ready and willing to deliver the goods and requests the buyer to take delivery, and the buyer does not within a reasonable time after such request take delivery of the goods, he is liable to the seller for any loss occasioned by his neglect or refusal to take delivery, and also for a reasonable charge for the care and custody of the goods. Now, my pal Poonam Rawat will take over.